What's popping, y'all? Welcome back to Pop Health. And today there's a lot of stuff we need to talk about that's going on in Texas in terms of our legislation and our special sessions, and that is SB Bill number 7, which is plopped up right here, as well as SB Bill number 4, which is propped up right here. And so as it says in the actual text, which will be linked down to the bio below, basically, an employer may not adopt or enforce a mandate requiring an employee, contractor, applicant for employment, or applicant for a contract position to be vaccinated against, you know what, as a condition of employment or contract position. Now, when we talk about employers, this isn't really just talking about federal or kind of like state employers that get state or federal money. This means that wherever you go to work at, whether you go to a bake shop, where you go to a coffee shop, whether you're working at Walmart, McDonald's, Chick-fil-A, wherever, they cannot force you to get a vaccine. As well as the fact that, as stated under this section right here, prohibited adverse action by employer. Basically, an employer may not take any adverse action against an employee, contractor, applicant for employment, or applicant for a contract position for refusal to be vaccinated against you know what. So basically, this is more so with individual rights based. If you don't want to get this vaccine, you're not forced to, and your employer can't punish you for it. Now, when it comes to private facilities like healthcare and all that, this is where there's an exception for certain, facilities, healthcare providers, and physicians. Basically, a healthcare facility or healthcare provider or physician may establish and enforce a reasonable policy that includes requiring the use of PPE by an individual who is an employee or contractor of the facility, provider, or physician, and who is not vaccinated against, based on the level of risk of the individual presents to the patients from the individual routines and direct exposure to patients. Now, what this means, and I'm using an example of MD Anderson or UT Southwest, some of the biggest, healthcare names in Texas. Basically, they can establish their own policy saying, hey, if you don't want to get vaccinated, that's cool, fine, GG, whatever, but you have to wear PPE because you're working with special patient populations, especially when you're talking about cancer patients with MD Anderson and with UT Southwestern. That is a big researching as well as medical school. So I like this provision of it because just because you are an individual person, you still recognize that there's some level of risk, your actions, as well as you not, getting the, vaccine has on other patients, and that is scientifically proven. Like, this is a public health matter. Now, going more talking about the administrative penalty, which is through the workforce commission. Basically, if someone files a complaint saying that, oh, I'm getting mistreated because of my vaccination status, the commission shall impose on an employer who violates this chapter an administrative penalty in amount equal to $50,000, up to $50,000, basically, for each violation, unless the employer, as applicable, hires the applicant for employment or offers a contract to the applicant for a contract position, or reinstates the employee or contractor and provides the employee or contractor with back pay from the date the employer took the adverse action, and makes every reasonable effort to reverse the effects of the adverse action. For example, reestablish employee benefits that you might have lost out or you're, required by law to have, due to being an employer of that company. So pretty much, a lot of companies can be under penalty if there is a complaint filed against them. And so this administrative penalty is very harsh, especially talking about smaller mom and pop shops who try to enforce some type of requirement for their employees, as well as big corporations as well. But I feel like, in my opinion, I've been visiting mom and pop shops that basically like are more likely to be like, okay, no, you need to be vaccinated, make sure the employees vaccinated. Like, we are a staple in the community, we need to make sure we're setting a good example. This is something to watch out for. This is something you need to be mindful of, because like I've said before, the whole pandizzy is not over. Stuff is still spreading, and like, yes, we can go outside, yes, we have like protective factors against it. We're not to a point where it's just like we need to overlook what this disease has done to vulnerable populations such as elderly, children, as well as like immunocompromised individuals. And I think that's something we need to be mindful when we look at this law, because now you're saying that private employers, one of the biggest tools that public health professionals could try to advocate for in order to control the spread of this disease, now they're not able to do it in Texas. This before, which has garnered a lot of attention. Looking at the summary, it relates to the prohibitions or on the illegal entry into or illegal presence in the state by a person who is an alien the enforcement of those prohibitions and certain related orders, including immunity from liability and indemnification for enforcement actions, and authorizing and requiring under certain circumstances the removal of a person who violate these provisions, also creating criminal offense. Now, before going to like specific the bill, the enforcement of this law is prohibited in these certain locations. Basically, when we talk about a public or private primary or secondary school for educational purposes, basically a student can't be subjected or be enforced with this law. A church, synagogue, or other established places of worship, a healthcare facility as defined under health and safety code, a safe ready site. Basically, that's a site for forensic examinations and treatment for SA survivors, as stated under here. Basically, under these sites, it's prohibited to try and enforce this law onto an individual, because those are, you know, basically safe spaces legally. And so this is something that you shouldn't, you know, do because it's the law. Now, looking at the order to return to national foreign nation for this, you know, law or proposed laws, the judge in the person's case at any time after the person's appearance before a magistrate in lieu of continuing the prosecution or entering in adjudication regarding of offense, dismiss the charge pending against a person and issue a written order in accordance with subsection C. Basically, this is a written order authorized by subsection B, A, or B must discharge a person and require the person return to the foreign nation from which the person entered on, attempted to enter, and may be issued only if the person agrees to the order, the person has not previously been convicted of an offense under chapter 51 of penal code, basically just other offenses, as well as the person is not charged with another offense that is punishable as a class A misdemeanor or any higher category of offense before the issuance of the order. Arresting agency. So basically what this section of the bill really talks about is that, you know, as long as a person, you know, who is suspected to be a, you know, undocumented immigrant, I'm not going to say illegal alien because of a lot of reasons, but basically if someone's suspected of being an undocumented immigrant, they basically get a written order to return home as long as they haven't committed another crime that they need to be prosecuted for. Now, the biggest issue about this whole bill is that there is probable cause in this. Now, basically probable cause is a requirement found in the Fourth Amendment that usually may met before police make an arrest, conduct a search, or receive a warrant. Basically, the Fourth Amendment protects you against unusual search and seizures, but you know, if there's probable cause, then all that gets thrown out the window. The courts usually find probable cause when there is a reasonable basis for believing that a crime may have been committed for an arrest, or even when evidence of crime is present in a place to be searched or seizure. Now, my definition of probable cause, you know, and this has been used a lot since, you know, talk about searching cars and stuff. If there is a heavy presence of, you know, a certain, you know, Mary Jane product, you know, basically, you know, coming out the window, if a officer decides to search your car, then they will probably have probable cause to search your car to make sure you're not, you know, smoking Mary Jane, or you distributing Mary Jane, or you have any other illegal activities going on in your car. Now, when it comes to undocumented immigrants, there is really no big probable cause into understanding if a person is undocumented without having to find evidence or search for evidence, because you can't really know if someone's undocumented or not. And that, well, a lot of people are saying this is open to racist prejudice, because you can only know by documentation. Like, you can't really smell if someone's like, you know, a undocumented immigrant. Like, the only way to really prove it is to like search for their papers, or, you know, try to find documentation or databases to find it. And now we're moving away from probable cause to just looking up someone's information. Now, a lot of advocates have said that this not only cause, you know, or may lead to widespread racial profiling, which, you know, is very high in Texas, obviously, because, you know, a lot of people try to conflate the border issue with a whole lot of other issues such as crime and all that, but also can cause the issues for asylum seekers, which is a very much different classification under constitutional law and international obligation. Now, going to the section of this article, we're talking about, you know, quote unquote illegal entry into the states. Basically, a person who is an quote unquote alien commits an offense if the person enters or attempts to enter the state directly from a foreign nation at any location other than a lawful port of entry. An offense under this section is a class B misdemeanor, except that the offense is a state jail felony if it is shown on the trial of the offense that defendant has been previously convicted of offense under this section. So basically, if they've been, convicted of this offense before, then basically this will be treated as a Class B felony. Now, when it comes to affirmative defense to prosecution, basically mean that you're immune from this in many ways. The federal government has granted the defendant, lawful presence in the United States, or has gave them asylum, under a certain section. I'm not going over that section right now. The defendant's conduct does not constitute a violation of a certain section, as well as the defendant was approved for benefits under the federal DACA Act between January, 2012 and July of 2021. So those are the cases where if you meet those criteria, you are under affirmative defense to prosecution under this act if you receive these, classifications. But where it gets really messy is the following federal programs do not provide an affirmative defense for purposes under subsection C of 1. Basically, this is the Deferred Action for Parents of Americans and Lawful Permanent Residence Program. Basically, parents of DACA children, or children who gain legal status but the parents came here, quote unquote, illegally. As well as any program not enacted by the United States Congress that is a successor or material similar to the program described by Section C3. As well as any program not enacted by the United States Congress that is a successor or materially similar to the program described by subsection C3 or subdivision 1. Now, keep going through the sections. Basically, illegal, quote unquote, illegal reentry by certain, quote unquote, aliens. A person who is an alien or quote unquote alien commits an offense if the person enters, intends to enter, or is at any time found in this state after the person has been denied admission or excluded, or has departed from the United States while an order of exclusion or deportation or removal is outstanding. Basically, you try to re-enter after you told them no, then that is basically a crime. Under this, it says an offense under this is a Class A misdemeanor, except that the offense is a felony of the 3rd degree if the defendant removal was subsequent to a conviction for commission of 2 or more misdemeanors involving drugs, crimes against person, or both. B, the defendant was excluded pursuant to section yada 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 because the defendant was excludable under that, as well as the defendant was removed pursuant to USC section of whatever. Basically, this makes this a felony of the 3rd degree if the defendant was removed for being convicted of 2 or more misdemeanors of what we just said, as well as the fact that if they have been excluded due to certain sections of the U.S. Immigration law. Now, this is a felony of a 2nd degree if the defendant was removed subsequent to a conviction for a commission of a felony. So this kind of like ups the severity of a, quote unquote, illegal re-entry if a person was already convicted, like I said, of another felony. Now, if a person refuses to comply with an order to return to a foreign nation, basically this will make this a felony of the 2nd degree. At this point, they're now being prosecuted under federal law, and pretty much not only will they have to serve out their conviction or sentence if they are convicted, but now going back to this certain provision, if a person conviction of an offense under chapter 51 of the penal code, basically a judge shall enter in a judgment in the case on order requiring a person to return to their foreign nation from which a person entered or attempted to enter. Basically, this order will be issued after the conviction has been served. So basically, not only if you refuse the order to go back to where you came from, figuratively speaking, now you not only have to face conviction, but now you are pretty much going to be forced to still return to at the end of the day. And let's say if this is like, in the same instance of a person, who can still probably turn down that latter, order of return, this might create a continually cycle of people getting convicted, reconvicted, and all that, because people don't want to return back for a lot of reasons, because they might have a family, they might have obligations here, they might have things to take care of, they might have built up a whole life that they can't just up and leave because some George ordered them because a nosy cop wanted to be nosy one day. Let's just say SB 4 is a terrible law because it now essentially makes it a crime to be an undocumented immigrant, which we can make a moral and legal argument throughout all of us. We are all undocumented immigrants because, lest we forget the history of the U.S., we didn't ask the Native Americans if we could peacefully settle on their land. We basically lost up to them. That's another topic for another day. But pretty much there's a lot of things that it leaves up to the air, basically, not only with racial profiling, but it doesn't offer many different protections for a lot of other vulnerable populations. So going down here, basically Democrats, since this was a partisan bill, obviously, you know who, but Democrats also offered amendments that will prohibit enforcement of the bill on college campuses, which weren't listed as a safe harbor site, would lessen the penalties for people incarcerated under the bill, would not apply to minor children, would not apply to victims of trafficking or other crimes who is cooperating with law enforcement and applying for a visa, and will only allow enforcement by State Department of Public Safety officers, and not just, anybody and everybody who's a cop, who are an agent, who are ICE and all that. And so all these amendments have failed. And crazy enough, there's also fiscal, things when it comes to this, and challenges, because it also rejected an amendment that will provide more funding for local governments, who leaders have testified to lawmakers that their budgets will take an enormous hit due to costs of, jailing, prosecuting, and providing a defense for migrants eventually charged under the bill. Basically, they're charged with trying to legally, take them back to the port of entry. If like an order was issued, that's their responsibility, and that takes a lot of time and money. And obviously this concern is valid, not the fact that I think, people should be taken back, all that. I don't believe in deportation, but pretty much, just looking at it from objective standpoint, it takes enormous hit, just to try to like provide shelter and take people back to their port of entry if they're found to basically enter the state quote unquote illegally. Like, that takes a hit on local government, who are charged to do this under this law. And so it's just crazy enough that Texas didn't, try to put that amendment in to give them more funding to do it. And so really add on to what I said about, a state really honing in on a federal law. Last week, a group of former immigration judges signed on to a statement warning that the bill is unlawful, and basically they're giving state court magistrates, judges, the ability to remove, people, which, like I said, they think it should be a federal, matter. And this goes back to 2012, where the U.S. Supreme Court actually struck down an Arizona law that sought to expand the state powers on immigration enforcement for the very same reasons. And now with Texas moving forward, this going to the governor's seat, or going for the governor's signature, this is going to open up a lot of people in the South to be like, maybe we need to revisit it, especially since we got a Supreme Court conservative majority, And so this has really got a lot of implications on like how other states may look at immigration, as well as like undocumented immigrants and all that. And one big thing I want to note with this video, I just want to show you the direct public health effects that law had, because pretty much it shows that the politics that are deciding the laws we have today will have direct public health effects. And whether SB 7 now basically allows individuals to control their own destinies with the vaccine, or SB 4, which makes it a illegal act for someone to become an undocumented immigrant, it's just one of those things where, pay attention to politics, pay attention to what's going on in legislation. I know it's boring, I know it's might be the most interesting, but it's something that we need to take hone on, because these will have direct impacts on people's lives in very bad ways that, you wouldn't wish on your worst enemy. And so with that being said, this has been Pop Health. If you found this very helpful, like, subscribe, turn on post notifications. If there's any clarifications I need to make, I'm not perfect, and it's one of those things where I'm trying my best to be thoroughly researched as possible. But if there's any mistakes or many things I need to clarify in the videos, please put it down in the comment section below. If you got just general thoughts, please put that in the comment section below. As well as look at my other content, I not only do a lot of political commentary when it comes to policies like this, but I also do a lot of reactions to things going on in pop culture. I did this one on Mr. Beast right here, so definitely look at that, and like, subscribe, comment, all that wonderful good stuff. Stay warm, stay frosty, depending on what part of the country you're in, and peace out.